For legal action to be successful, harassment in the workplace must rise to the level of creating a hostile workplace environment, unless there are shocking acts committed. Most workplace harassment cases are unsuccessful. The article talks about how to prove workplace harassment. So, we are going to watch about the how to prove harassment in the workplace.
Method 1. Understanding workplace harassment. First is know the definition of workplace harassment.
Workplace harassment is unwelcome conduct based on a protected condition. Harassment only becomes unlawful if it becomes a condition of employment or advancement.
Step 2. Recognize the protected classes of people.
For workplace harassment to be unlawful, it must be based on one of the protected classes of people. Just because you belong to a protected class does not protect you from all harassment. For instance, you have no recourse against an employer who harassed you because of your weight.
Step 3. Determine any conditions of employment.
If the employee being harassed must endure the harassment or risk being fired or not promoted, the harassment is unlawful. Retaliation for attempting to put an end to unlawful workplace harassment is also unlawful. Some examples of retaliation include firing the reporter upon learning of the report and not being able.
Step 4. Decide if the conduct is severe.
Most workplace harassment suits fail because the harassment is not considered severe enough. The conduct must make the work environment intimidating, hostile, or offensive to a reasonable person. Courts consider a variety of factors when deciding the severity of the conduct.
Finally, recognize common practices.
There are many different forms that harassment can take. It would be virtually impossible to list them all in one article. Common types of workplace harassment include discussing sexual activities.
Method 2. Gathering evidence of workplace harassment. First is read the rules of evidence.
The rules of evidence for your jurisdiction. Realize that at the administrative level, prior to going to trial, these rules will be somewhat relaxed. You should plan to gather evidence that is generally admissible in a court of law.
Step 2. Gather physical evidence.
Physical evidence can be very persuasive to administrators, judges, and juries. You want to collect and save as much physical evidence as you can. Physical evidence includes documents showing good reviews before the adverse employment action.
Finally, identify witnesses.
Witness testimony is also a form of evidence. If the finder of fact believes the witness, their statements can be persuasive. Witnesses must have experienced the topics of their testimony firsthand.
Method 3. Preparing your case. First is consider hiring an attorney.
Employment discrimination law is very detailed and fact-specific. It also tends to favor the employer in most jurisdictions. A local attorney should be familiar with the laws in your area and how they are applied in your court system.
Step 2. Give required notice.
In most cases, you must notify your employer that the harassment is occurring and ask that it be stopped. If your immediate supervisor is the harasser, you should attempt to report to the Human Resources Department or higher level management.
Step 3. Complain to the proper agency.
Both states and the federal government have laws and agencies that make workplace harassment unlawful. To report to your state government, locate your State Fair Employment Practices Agency, FEPA. You can locate your local field office or call them at 1-800-669-4000.
Step 4. Work with the agency.
If you try to file a lawsuit prior to going through the agency process, it will likely be dismissed. Cooperate with the agency and follow the advice of your attorney. Most likely, the process will include your initial report, your employer's response to your statements.
Finally, sue if granted a right to sue letter.
If the agency grants you a right to sue letter, you can file suit in either federal or state court. This will likely be a very complex case, so you should retain an attorney. Many courts require attempts at settlement prior to trial.
We hope it is useful to you. Please subscribe to our channel to upskill yourself.